welcome to the deep dive. You know, you have probably seen the movie montage of like the perfect international romance, right?
Yeah, the classic cinematic dream.
Exactly. But what happens when that sort of borderless love collides with rigid geographical, legal, and tax codes? Today, we are pulling from this really comprehensive guide on international marriage recognition and financial rights.
Which is such a crucial topic.
It really is. And the source also examines how administrative platforms like Weddizer are attempting to sort of alleviate the bureaucratic burden for cross-border couples. So our mission for you today is simple. We want to arm you with the critical legal and financial knowledge you need so you aren't completely blindsided when taking a relationship across borders.
Because it happens a lot more than you'd think.
For sure. Okay, let's unpack this. Because before a couple can even begin to worry about, merging their bank accounts or buying a house or even arguing over whose turn it is to do the dishes in a new country, they actually have to figure out if their marriage exists in the eyes of their new local government.
Right. And what's fascinating here is that we tend to treat marriage purely as a universal human experience, an emotional bond.
Yeah, of course.
But a government views marriage as a strict jurisdictional contract. It is, at its core, an economic partnership that fundamentally alters the state's responsibilities toward those two individuals.
Meaning everything from property rights to welfare, right?
Exactly. International marriage recognition simply refers to whether one sovereign nation legally accepts a marriage contract that was executed in another. The trap so many couples fall into is this assumption that a marriage certificate is, well, like a passport.
Universally recognized the second it gets stamped.
Precisely. That assumption is why so many cross-border couples end up in absolute administrative nightmare scenarios.
Because people definitely assume that if you stand up, say your vows, sign the official register in one country, you are just universally married across the globe. Like, done deal.
I mean, it makes sense emotionally, but legally, a marriage performed abroad is generally recognized if it follows the laws of the country where it took place, but that recognition is rarely automatic when you actually cross a border.
Wait, so what do you have to do?
Well, many nations require an entirely secondary layer of bureaucracy just to validate that foreign marriage before they afford you any legal rights. We are talking about formal registration processes, certified and notarized translations of your documents, and really complex authentication procedures.
So it's basically like trying to use a foreign power adapter. The shape of the plug, like the marriage itself, might be perfectly fine, but without the right converter, like an authentication or translation, the legal current just won't flow, right?
That analogy gets right to the heart of the mechanics. I love that. Think of authentication procedures like getting an apostille, which is a specialized international certification, as that physical converter.
Right, okay.
Because a foreign government cannot easily verify that a piece of paper from a town hall thousands of miles away is legitimate. They need their own legal mechanisms to prove the marriage wasn't fraudulent.
They have to make sure it met their specific local standards for consent, that the documents aren't forged, all of that.
Exactly. Until you plug that authenticated converter into their legal system, your marriage generates zero legal power in that country.
But wait, I have to push back on this a little bit. If a couple has lived together for years, they have a wedding album, their families were there, they paid the local fees in the country they got married in, why would another country care? Why are they so incredibly skeptical?
Well, because the new country is protecting the integrity of its own legal and financial ecosystem. They are about to grant you massive privileges based on this relationship.
Like immigration rights and tax benefits?
Yes, and inheritance rights. They can simply take your word for it or trust a localized document. They just don't have the jurisdiction to verify. Skipping this foundational step creates a massive ripple effect.
A domino effect of delays and lost protections.
Right. You lose access to the very legal protections that marriage is designed to provide. You can't sponsor your spouse for a visa. You can't be added to their localized health insurance. And you have literally zero automatic decision-making rights in a medical emergency.
Oh, wow. Which brings us right into the day-to-day reality of this. Here's where it gets really interesting. Let's talk about the immediate financial mechanics of living together in a new country. Once we move past the ceremony and the paperwork, the realities of property ownership hit.
And this is where a lot of assumptions completely fall apart.
Seriously, because reading through this material, mechanics of how property is handled internationally are genuinely shocking. Are you telling me that if a couple buys a house together in a new country, local laws might just decide it belongs entirely to one person if they didn't explicitly check the local property rules?
I'm telling you exactly that.
Yeah.
And that scenario plays out far more often than you might think. Property ownership defaults differ wildly depending on the jurisdiction.
So what are the defaults usually?
Well, some countries operate on a default of community property or joint ownership. Mechanically, this means any asset acquired during the marriage is automatically considered equally owned by both spouses.
Regardless of whose name is actually on the physical deed or the purchase agreement, right?
Right.
Which feels highly intuitive. That is the default mental model most people have when they say, hey, we're buying a house.
But crossing a border changes that default. Other countries, or even specific provinces within a single country, operate on separate property defaults.
Meaning?
In those jurisdictions, ownership is dictated strictly by whose name is on the title, unless you explicitly and legally contract otherwise. So imagine a couple moves abroad, they buy a home, but because one spouse hasn't secured local employment yet, or, their foreign credit score doesn't translate, it is vastly easier to put the mortgage and the deed solely in the working spouse's name.
Just to streamline the paperwork and get the house.
Precisely. But fast forward 10 years. If the relationship dissolves or the spouse on the deed passes away, the other spouse might discover they have absolutely no legal claim to the home they have been living in.
That is terrifying.
It is. The local law simply views them as a tenant or a guest because the jurisdiction defaults to individual ownership, and their name just isn't on the title. Making assumptions based on your home country's laws is the biggest trap cross-border couples fall into.
That fundamentally changes how a couple needs to approach literally even the smallest financial decisions. And it's not just big assets like real estate. The materials point out that banking, like just opening a shared checking account, can become this massive hurdle.
Oh, banking is notoriously difficult for international couples.
Because they want to open joint accounts to pay for shared groceries, rent, utilities, but local banks operate under strict know your customer regulations to prevent money laundering.
Right, the KYC laws.
Yeah. So they require absolute proof of a recognized legal relationship before they will allow two foreign nationals equal financial access to a single account.
Because a local bank cannot grant joint financial liability without that foundational marriage recognition we discussed earlier. If your marriage isn't locally authenticated, you might be reduced to, Venmoing each other for household expenses across international borders.
Which introduces the absolute nightmare of currency exchange fees and monitoring fluctuating exchange rates constantly.
Exactly. And maintaining a highly organized, recognized paper trail of your shared finances becomes even more critical when you face the immigration and residency process.
Oh man, the visa process. This is where the movie montage really did lie to us. The cinematic narrative is that you marry a local and you instantly belong to their country. Boom, done.
The administrative reality is that marriage does not automatically grant citizenship anywhere on Earth. It merely gives you the legal standing to ask the government for permission to stay.
And the burden of proof required for that application is just monumental.
It is. Immigration departments operate from a baseline of extreme skepticism. They are actively looking for evidence of a fraudulent marriage designed solely to bypass immigration laws.
So presenting the authenticated marriage certificate isn't the finish line, it's just like the entry ticket to the interview room.
The certificate just proves you signed a contract. The immigration process requires you to prove the authenticity of your shared life. You are required to produce mountains of secondary evidence.
Like joint lease agreements, commingled bank statements showing shared expenses over time.
Yeah, photographic evidence of your relationship timeline, sworn affidavits from friends and family, and extensive financial records. They need to prove the sponsoring spouse earns enough to financially support the immigrant spouse so they do not become a burden on the state's welfare system.
And while you're gathering years' worth of utility bills to prove your love to a government official, you're also dealing with the raw economics of an international relocation. You've got massive international wire transfers for deposits on housing, and just the sheer cost of moving a life across an ocean.
A long-term financial strategy for an international couple requires budgeting specifically for administrative friction. The relocation expenses go far beyond just shipping boxes.
You're talking visa application fees, costs for medical exams required by immigration, fees for sworn translators.
And retaining local legal counsel, which is why keeping financial records organized is just vital for both banking and immigration processes.
Okay, let's look at the next phase. Let's say a couple has successfully navigated all those initial hurdles. Their marriage is recognized locally, they figured out the property laws so they both actually own their house, the joint bank account is functioning, and the residency visa is finally approved.
Oh, they are settled in.
Exactly, they are settled. Now, the focus naturally scales up to the long-term mechanics